The next matter to come before the court this morning is Jacob Moss et al. Versus Lorain County Board of Mental Retardation et al. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and you wish to reserve that time, please let me know. I'm keeping the clock this morning and keep you apprised of the passage of time. We've read the briefs. We're ready to proceed with the argument.
May it please the court, my name is Patrick Roble and I represent Lorain County Board of Developmental Disabilities. I respectfully like to reserve 3 minutes for rebuttal. The central issue presented before this court on appeal is whether a functioning coffee pot constitutes a physical defect for purposes of the RC 274402B4 exception to political subdivision immunity. It's the board's position that a working coffee pot does not constitute a physical defect under the B4 exception because it operates as intended and does not contain any perceivable imperfections that diminish its worth or utility. In the alternative, in the event this court determines that a coffee pot does constitute a physical defect, the board also asserts that it's entitled to additional defenses under the third tier RC 274403A5 defense, specifically because the supervision of students or the discretion involved in designing the construction of a kitchen area is a type of discretion contemplated under that defense. As a result, we respectfully request that this honorable court reverse the April 7th journal entry and grant summary judgment in favor of the board as to the amended complaint in its entirety under RC Chapter 2744. Specifically, the Ohio General Assembly has established a 3-tiered system for determining whether or not a political subdivision is entitled to statutory immunity under RC Chapter 2744. The first tier, political subdivisions are entitled to general immunity for performance of governmental proprietary functions. The second tier, court must determine whether any of the 5 narrow exceptions apply to best political subdivision of immunity. And in the event the court determines that there are such exceptions, it must then proceed to determine whether or not there are any defenses that would reinstate immunity. Here we would assert that it's undisputed that the board is a political subdivision, that none of the exceptions apply because the coffee pot is not a defect, and that even if it does, the third tier defenses apply.
You're focusing, and I understand, as you did in your brief, on the coffee pot. What about the testimony of regarding the counter on which the coffee pot sat, how deep or narrow it was, based on the testimony of one of the witnesses that it was pushed back as far as it could go, and on the other hand, it was right within a couple inches, 5 inches or so, from the wall. What are we going to find in the record regarding that?
There is no evidence that the countertop itself had any imperfections in it. That testimony is whether or not the coffee pot was positioned in a certain way on the countertop. But regardless of where it's positioned on the countertop, the question is whether or not the coffee pot itself is a defect, not whether the countertop is a defect.
Well, how can you limit design to simply the coffee pot? I understand it's the coffee pot that held the coffee that caused the injury, but it's not the beginning and the end of the inquiry, no more than the inquiry could extend to the design of the way that the tables were designed to keep the children out of harm's way. Could not that be a part of the court's consideration?
I would say no for 2 reasons. One, courts have held, specifically the Shore, cited in our brief, that the court is not, when you're looking at physical defect, you're not importing the idea of design and construction into the physical defect analysis. physical defect does not import some sort of product liability or design considerations. The consideration is whether or not the countertop performed as it was intended to perform, or whether or not the coffee pot performed as it was intended to perform. If you start looking at the design and construction, you're looking at the defenses that a political subdivision would have as to it. And if we're importing design and construction into the analysis of whether or not there's a physical defect, I would want to say that that would contradict many of the other Court of Appeals decisions which have defined a physical defect as a perceivable imperfection. It diminishes the worth of utility. But also that would allow plaintiffs to argue anytime that they feel that there's a physical defect, they can assert that there's a design imperfection and that the political subdivision didn't design something properly, and that resulted in in injury. And I would say that that greatly expands the General Assembly's intent to limit political subdivision injuries under the RC 2744-02B4 exception.
Thank you.
Returning back to, there's no dispute in this matter that the board is a political subdivision and that the provision of the system of public education and the maintenance of buildings used for development of utility disabled are governmental functions. Therefore, the burden is on plaintiffs or appellees to demonstrate that there is an exception to political subdivision immunity. They have asserted the RC 2744-02B4 exception, which provides, as we discussed before, a limited exception for negligence caused by, employee negligence within or on the grounds of political subdivisions due to physical defects and on the grounds of buildings used in performance of governmental functions. As this exception indicates and other courts have held, there are three distinct elements that plaintiffs must prove. That would be employee negligence on the grounds of a government building and due to physical defects. And it's our assertion that plaintiffs have not demonstrated employee negligence or physical defect. Specifically with respect to the negligence, it's well established that negligence requires a duty, a breach, and injuries arising proximately therefrom. The existence of a duty is imposed by the foreseeability of the injury. And the foreseeability of an injury, or the existence of an injury foreseeability, is whether a reasonably prudent person would anticipate that injuries are likely due to the performance and non-performance of a specific act. And thus, the test for foreseeability is whether or not, depends on the knowledge of the individual at the time. Without the requisite knowledge, a duty is not imposed. It's our position that the employees do not have the requisite knowledge at the time of the injury. Specifically, I would point the court to the fact that there were no rules or regulations that prohibited coffee pots from being in the classroom. Coffee pot was not something excluded under MOS's IEP, the Behavior Support Plan. The room was regularly inspected by the Ohio Department of Health, and there's no evidence on the record that the Department of Health had made any concerns about the existence of coffee pots. And probably from our perspective, the most telling is that coffee pots have been in not only this classroom, but other classrooms in the Murray Ridge Center for over 20 years without incident. So we would think that that would indicate that the individual employees could not foresee that this was likely the result of having coffee pots in the classroom. And then even if it is foreseeable, it's our position that the coffee pot does not constitute a physical defect. There's absolutely no evidence on the record that the coffee pot did not perform as intended, or was less useful than designed, did not contain any perceivable imperfections, and their arguments regarding the defects in the kitchen area itself. If you remove the coffee pot from the kitchen area, there's nothing in the kitchen area, whether the counters or the stove, that caused an injury. It is the coffee pot that caused the injury. And courts look at the actual instrumentality that causes the injury, which in this case was not a countertop, was not anything in the kitchen area, it was the coffee pot itself. And as a result, we would say that a physical defect does not exist, but in the event this honorable court does determine that a physical defect exists in the classroom, it's our position that the board is still entitled to assert its RC 2744-03-85 defense to reinstate immunity. Specifically, that defense applies to the exercise of judgment and discretion in determining whether or how to acquire equipment, supplies, materials, personnel, other resources, as long as it's not done in bad faith, malicious conduct, reckless, or wanton. This court has previously determined that the supervision in MOS 1, the supervision of students, is the type of discretion contemplated under that defense. Other courts have also held that. Therefore, we would say that the exercise of supervision of the students was a discretionary act, and the only reason that the court would not have the defense under A5 would be if plaintiffs can demonstrate that the conduct was reckless or wanton, as they've alleged. Wantonness indicates that the individual did not exercise any care whatsoever under circumstances when probability of harm was great, and recklessness is defined as a conscious disregard for a known or obvious risk, or in circumstances that demonstrate it's substantially greater than mere negligence. We would say there's no evidence in the record that any of the employees engaged in, well, what some courts have cause a perverse disregard. Specifically, I would point to the fact that Oppenheimer, the teacher there, specifically arranged circle time with a gap in the middle to allow Jacob Moss to come in and out between himself and the teacher's aide. She specifically instructed the teacher's aide to sit directly behind Jacob Moss so he couldn't run. There are several examples in the record when she's instructed the teacher's aide on how to maintain proper supervision of Jacob Moss. And again, I would point to the fact that if you look at the coffee pot, it had been in the classrooms for 20 years. I would think that this evidence would show that the teacher or none of the other employees engaged in a perverse disregard towards Jacob Moss's safety.
And counsel, you're now reaching into your 3 minutes of rebuttal time.
I will reserve that. Thank you.
Good morning, Your Honors. May it please the Court, my name is Paul Flowers. I represent the plaintiff appellees, Jacob and Kim Moss. I thought I'd start with Judge Moore's question, which I thought got right to the heart of this. This case, it's now 7 years old. This case has never been about whether a hot pot of coffee is a physical defect. All one has to do is read Moss 1, this Court's first decision, and see that this case is about whether the design and maintenance of the kitchen area is a physical defect. That was the holding of this Court. And this whole coffee pot discussion that we just heard about is a ruse. It's just designed to get the Court off Moss 1 onto their ground and decide the case their way, which they've been trying to do for 7 years now. Moss 1 spelled out under the exact same facts that we have here how the second-tier subdivision unit can be satisfied. We've acknowledged there are political subdivision. The second question is, can we establish one of the 5 exceptions? The B4 exception is the one that was identified by this Court in Moss. This Court squarely held that a kitchen defectively designed to maintain kitchen area could qualify as a physical defect. In particular, the counter area, the counter where the coffee pot was situated, was waist high. Every adult who testified said it was waist high, so it's like this. And there's no dispute that a small boy, now he's not large, he's small for his age, a small boy, within a matter of seconds, was able to reach Ms. Oppenheimer's hot pot of coffee and scald himself. That's undisputed testimony. Yes, sir.
Who's waist height?
Well, so Ms. Hamilton's testifying, she says waist high.
Child's waist or the adult's?
I'm sure she's referring to herself. And to give them the benefit of the doubt, I'll say an adult, but she's shorter than me.
Okay,
you know?
well, I guess it's relative. Then.
Yeah.
So and I have a question about this coffee pot thing. Are we talking about like a permanently affixed coffee machine to the countertop?
No.
Is like just like this bun with a little, like a Mr. Coffee machine with the coffee pot that comes off of it?
Right, my guess is it
Does
was.
it sit anywhere it wants on the counter, or you
Right.
can put it anywhere you want it on the countertop?
That's definitely true.
Okay, so it could be back against the wall, or it could be closer up to the front.
Right.
Okay, so it's sort of like, depends on who's in there, where the coffee machine is going to be at any given time.
Right. Right.
It's not permanently affixed to the kitchen area.
Right. And if you look at it, there's conflicting testimony about where it was, because Ms. Oppenheimer, was in charge of that classroom. She's the employee of the board. She says, oh no, I always pushed it back as far as I could.
But anybody could have moved it closer to the front of the counter.
Yeah.
Was the depths of the counters pretty standard countertops? Was it something exceptional, these narrow counters, or were they normal 25 inch?
The testimony I recall is 3 to 4 feet, which is.
They're pretty significant countertops.
Right. And so Ms. Oppenheimer, she's the only person drinking the coffee as far as the record reveals. It's her coffee pot, her classroom.
But all the
kitchen area.
classrooms have coffee pots in them.
I'm not sure that's an established fact, that they all did. This one was hers. Ms. Hamilton, the aide who chases Jacob in there and wrestles with him over the coffee pot, she said it was inches away from the counter. And the only logical person to be using that pot is Ms. Oppenheimer, it's her pot. Going to the facts of this case, this effort's been made to establish that this is some sort of structure during circle time where Jacob is protected. There's the table set up and there's the gap in the middle. And the gap was where Ms. Oppenheimer sat. She's in charge of everything there. That was to direct him towards her, but it was not set up so that he could, so he would be unable to reach the kitchen area. Now keep in mind that this is a boy who's been diagnosed with Down syndrome. He has been diagnosed with impulsivity that's charted in virtually every record he's got. In one 5-month period, and I found this incredible, he escaped 32 times per month. 5-month period, 32 times per month he escaped from an adult. So what happens here is on the first day of school at the Murray Ridge School, Ms. Oppenheimer takes the least trained, least experienced individual there, which is Ms. Hamilton, who's an aide, former operator, telephone operator there, assigns her to the most difficult child, which is Jacob Moss. Ms. Hamilton has a very difficult time with him that day. She expresses that to Ms. Oppenheimer at the end of the day. Ms. Oppenheimer says, you need to stay with them. I think skin on skin is the word she uses. Second day, he escapes once from circle time. We put him back, escapes the second time, and that's when he runs into the kitchen area and accesses the hot pot of coffee. Every adult with small children knows that you do not leave pots of coffee, knives, any sort of dangerous items within easy reach of children, particularly when you get a countertop that's this high, waist high. What happened was not something that no one could predict. So another aide, this is Ms. Wilson McLilly, she testifies on page 170 of her deposition, and the question talks about it's foreseeable that Jacob could grab something on the counter. Question, and if that thing happened to be a hot coffee pot, it was foreseeable that morning that if he darted from circle time and he went into the kitchen area and the coffee pot was within reach, that he might go ahead and grab it, correct? And then every defense lawyer in the room objects, and the answer is yes. Every good parent knows that that's a risk. They should have known that that was a risk here, particularly with a child like this who's being watched by the least experienced aide in the whole school system. And a lot was made in their brief of the fact that this aide isn't employed by the board, she's employed by the Elyria school system. I think that hurts them even worse. I mean, this is somebody who just is not trained for this type of student, this type of child, who's put in charge of this. And they can't walk away from their responsibilities just by assigning somebody to Jacob who happens to be employed by somebody else. their duty is established by law. That's a DuBose case in this court. All schools have a duty to protect the children who are put in their care. And then we've got their own investigator. This is Ms. Strebel. She's testifying on page 157 of her deposition. Question: the room was within the control and supervision of the MRDD, correct? Answer: correct. Question: would you agree with me that it's the MRDD's responsibility to make sure that the specific room where that coffee pot was located was safe for the children who were there? Answer: yes. That's their responsibility. And reasonable minds could certainly find here that they failed miserably. Now this is a third appeal here. Judge Moore, this is your third time on this case, and Judge Hensel was on the second one. This court has established the law to be followed in this case. And in Moss 1 said very clearly that based on the allegations of a defectively designed kitchen area with a countertop that was dangerous instruments easily accessible, that could qualify as a physical defect. That's Moss 1. And the facts that were established during summary judgment are the exact same facts that were alleged in that complaint. They're not suggesting otherwise. In fact, if anything, the facts are more egregious because we now do have more details about the fact that it's a low countertop, an unsecured coffee pot, easy reach to a small child with impulsivity issues. And we know now, which we didn't know then, that Ms. Oppenheimer, their head employee, had assigned the least trained, least experienced employee to watch Jacob. We know all that now.
Just to refresh my recollection, I know that Moss 1 involved a motion to dismiss. If I'm not mistaken, it didn't reach 12.
To be really technical, doesn't really matter. I think it was a motion for judgment on the pleadings.
That's right.
As was Moss 2.
Both of them.
Okay, Moss 2, they said because we settled with Hamilton, that somehow changed everything.
Okay.
You know, and
So
so we get
this-
another appeal.
So now we're looking at this on a motion for summary judgment.
Correct.
So you're not suggesting, are you, that law of the case applies from the standpoint that this court must affirm just because this has come up before in a different context? Or are
No,
you?
I wish it was that simple, but no.
Okay, I just wanted to make sure that.
Yeah, look, I should be real clear about this, but what we're saying is this. You use a motion for judgment on the pleading to establish uses of law. And that's what happened in the first one. This court said, yeah, you can prove that there is a defectively designed and maintained countertop in this defectively designed and maintained kitchen area, then you get through the B4 exception. All right, so the question now is, and the only question is the evidence in the record that's been submitted for summary judgment purposes, does that support those allegations? And it absolutely does. I mean, there's nothing in their brief where they suggest they came up with something that's significant that wasn't in the complaint. You know, they have no facts on their side that mitigate against any of this. I mean, it's a defectively designed kitchen area. And I got to say, I mean, Moss 1 has now been cited, I checked this morning, it's been cited over 20 times. Not one court has criticized Moss 1. In fact, the DiMartino case, the 7th District followed Moss 1. They had a situation where an employee was mowing a field near the I think it was the marching band, kids outside at least. The chute on the lawnmower had been detached. There's supposed to be this protective chute, and a rock was thrown out and hit one of the students in the head and caused some very serious injuries. And in DiMartino, the 7th District cited Moss to say, yes, it's a perceivable imperfection, that mower. It's a rock caused the injury, but it's the perceivable imperfection of the mower that satisfies the physical defect requirement. And like I said, it's a well-received decision. There's no reason for this court to reconsider Moss 1. The only question should be, let's look at the evidence, and does the evidence support what was alleged in the complaint? Those facts that we were using in Moss 1, it absolutely does. The one case that we found from the 9th District was Wygant versus Ward. It's a 2013 case, and there this court looked at, there was an earlier appeal where a motion to dismiss had been reversed and the case sent back. And then in the second appeal, this court said, you know, it doesn't matter what happened at trial, you're still stuck with that decision. You know, that's the law. And you know, you look at the facts that have been developed, but that's the law. And that's what we're saying here, the same thing as Wygant. The law was established, let's just look at the facts. quit trying to monkey around with this idea that it's really the coffee pot that was the physical defect, get back on track. And here it's, the judge found below, the facts are spot on to what was alleged. Just to kind of finish up, on the physical defect, I don't think there really could be any serious criticism of Moss 1. I mean, perceivable imperfection is the definition that everyone agrees on, and there's plenty of situations you can think of, such as if a kitchen, a school kitchen is designed with a knife rack that is too low and the children can reach the knives, if there's electrical outlets that are not child resistant, if there's cabinets that are not attached to the wall and can be easily pulled over when the door is open.
So what is the perceivable imperfection of the countertop in this case?
The perceivable imperfection, you have a countertop that allows easy reach to dangerous items on it. Countertop that's up here, a regular countertop even down here, you don't have that. Or as Judge Schaefer was kind of alluding to, if you have a coffee pot, maybe the dangerous items are all situated back and they can't be moved out. Maybe some sort of barrier, or maybe sliding doors covered, something like that. But that's all design defects, and that's what this court said in Moss 1 could fall within that physical defect. This physical defect requirement was added to the statute probably about 15, 20 years ago, and it was always obvious to me that it was just to make sure that it isn't any type of employee negligence that allows a claim. It's premises liability types of cases, and that's what we have here. We routinely have situations where the electrical outlet may function as it's intended, but if it's not child resistant in a school where students are going to be able to access it, that's physically defective. The purpose of this room is to provide a safe learning environment. You don't have that when you have dangerous items within easy reach, and that's what we have in this case.
And the children are drinking coffee, correct?
Correct. Let's hope not. Right. It's Ms. Oppenheimer's pot, and that's been established. And I know she claims she never had an incident like this before, but it was foreseeable nonetheless. I mean, all good parents know, even with regular adult countertops, you don't put dangerous items within easy reach or allow dangerous items within easy reach. You've got a low countertop like that, anything that's on there is going to be accessible, and that's what happened in this case. We've talked about the first two tiers for the immunity analysis. The third one is just whether they can restore immunity with this discretionary function exceptions. This court held in Hallett versus Stowe Board of Education in 1983 that we construed these requirements very narrowly. You have to have a high-ranking decision, policy decision, that we're going to do this because the risks are outweighed by the advantages. And we have no such testimony here. No one said that we had to design a countertop this low and put dangerous items on it within easy reach. No one has testified to that. No one has suggested that there was some sort of advantage from that. In fact, as soon as this incident was over, they banned all hot liquids on the premises. No hot liquids. And that should have been the policy all along. They controlled the water temperature throughout the whole school so that children couldn't scald themselves in the bathrooms or wherever. The State Department of Developmental Disabilities had issued a bulletin in 2006 warning of hot liquids. We have these teachers, and Ms. Wilson-McWillie is not the only one, who said that, you can foresee that if kids are in that room, they'll have easy reach to anything on that low counter.
And counsel, regretfully, I need to inform you, you've utilized your entire 15 minutes this morning. Thank you.
Well, I will sum up. Please affirm. Thank you.
Counsel, you have about 2.5 minutes remaining.
Just as to the idea of physical defects can be plugs, as opposing counsel was saying, knife racks or designs or things of that nature. I think that gets to the point that we're trying to make, is that if you expand the definition of physical defect to include anything that plaintiffs wish was designed differently, that greatly expands the scope of the physical defect exception. And what they're asking for this court to say is that any time that a plaintiff can come up with a safer alternative or something that should have been designed differently, that constitutes a physical defect. I would say that's inconsistent with the way the courts have interpreted that. and would greatly expand the scope of the physical defect exception in contradiction to the General Assembly's intent on limiting that exception. I would only speak to the idea of coffee pots in classrooms. Todd, McLilly, Musich, and Pollock all testified to their coffee pots in other classrooms. Pollock is a teacher who also said she had maintained a coffee pot in her classroom. As to the idea that Oppenheimer assigned Hamilton, the record is clear that the assignment was done by the school district of origin. It was not something that Oppenheimer herself did. The Elyria City School District assigned Hamilton to Jacob Moss, and that is clear from the record. As to the statement that McLilly said it was foreseeable, she testified on pages 107 to 110 of her deposition that she had no reason to believe that there would be a spill and did not see the coffee pot as a risk prior to attorneys asking her a legal conclusion. And I would speak to the DeBose case, specifically cited by appellees, says that there's no heightened duty for teachers. They are held to the same standard of reasonable care as anybody in the general population. Accordingly, we respectfully request that this honorable court reverse the April 7th journal entry and grant summary judgment as to the amended complaint in its entirety.
Thank you. Thank you both for your presentations today. The court will take the matter under advisement, issue a written decision, which will be mailed to all sides, as well as posted on the Ohio Supreme Court website, which can be linked to the 9th District Court website. Thank you.
Thank you.